Hello, Ohio Realtors. With the pending NAR settlement announced earlier this year, many of our members around the state have raised questions about the anticipated practice changes. We currently expect final rules to be implemented August 17th, 2024, so circle that date on your calendars. And the time to start preparing for these changes is now. To help guide our members navigate the impact of this settlement agreement, NAR has recently released a list of frequently asked questions and answers to help all of us understand the impact of the anticipated rule changes. You can find this incredible resource on the website FAQs.Realtor, and we have a link on our website, ohiorealtors.org, under our NAR Settlement Update page. As of the recording of this video, there are currently just under 100 questions listed, which may include some questions that you or others in your office might have. Here are some highlights from the new frequently asked questions. As you all know, as part of the settlement agreement, NAR has agreed to require MLS participants working with buyers to enter into written agreements with their buyers before touring a home. One of the frequently asked questions we've encountered asks, what does it mean to be working with a buyer? NAR makes clear that there is a distinction between MLS participants who provide brokerage services to a buyer, such as identifying homes, scheduling showings for the buyer, facilitating negotiations, presenting offers, or other brokerage services on behalf of a buyer. They distinguish that from MLS participants who simply market or just talk to a buyer when acting on behalf of a seller. This leads to a related question. Are written buyer agreements required when listing agents talk with a buyer on behalf of a seller only, or as subagents of the seller, often in a showing or open house situation? The answer to that is no. If you are working for a seller or a subagent of the seller, then you are not working with a buyer under the scope of this rule change, and thus no buyer representation agreement is required. Another question that we've received is, are written buyer agreements required in a dual agency scenario? For example, when a single agent works for both a seller and a buyer. The answer here is yes. If an MLS participant is working as an agent for a buyer, even though they're also working for the seller, a written agreement is required. Another significant rule change will require that offers of compensation be removed from the MLS. So this begs an important question. Can buyers and buyer brokers rely on an offer of compensation that was on the MLS prior to the effective date of the MLS policy changes? If the sales contract is signed before the MLS policy change, the buyer broker should be able to rely upon the offer of compensation even if the closing occurs after the date of the policy change. But if the sales contract is not signed before the date that the MLS implements the policy changes, the offer on the MLS will not be valid, and buyers and buyer brokers may wish to protect themselves in writing with the listing broker or seller through such use of a buyer-broker agreement or including the offer of compensation in the sales contract. Important reminders at this time. This settlement is still pending final approval, with final approval currently expected late 2024. These practice changes, however, are set to go live on August 17th, 2024. NAR is offering their accredited buyer representative designation for free. So we strongly encourage those of you out there to sign up and take advantage of this opportunity to stand out and demonstrate your realtor value. Be sure to regularly check FAQs.Realtor and our website, ohiorealtors.org, for NAR settlement updates.